right, we're going to go ahead and get started. I'm Erin Rivelis. I'm one of the psychologists here at SURS, and I'm happy to welcome you along with my colleagues Ida Barisi, Dr. Rosa Sejo, Dr. Monica McQuaid, Miriam Franco, and Marcel Pachter to SURS's second annual transition planning webinar. Today is actually the second in a series of 3 webinars. We had one last week and we have one next week as well. A couple of pieces of housekeeping before we get started. We're going to be recording today's webinar, so it will be available for those interested after the webinar. We ask that you stay on mute throughout the webinar. If we have time for a Q&A at the end, we'll ask you to unmute yourself so that you'll be able to ask your questions. But if you have questions throughout, you can certainly feel free to type any questions in the chat box, which we will be monitoring throughout, and we'll do our best to answer your questions. You can also feel free to send any questions to the SURS Transition Fair at montefiore.org email address. And we are monitoring that email address. And so we'll be able to do our best to answer any questions that are sent to that email. I'll also be putting that email address in the chat box so that you have access to it. We have a survey that we'll also be putting in the chat box that we ask that everyone please complete at the end of the webinar. We're really interested in getting people's feedbacks regarding the webinar and to help us for planning future webinars. In the days following today's webinar, we will be sending everyone email addresses. Not email addresses. We'll be sending everyone emails so that you'll have access to not only the survey that we'll post in the chat box, but also some additional resources regarding transition planning that we're happy to share with everyone. So if you have not registered for the webinar, or if you did register but did not include your email address, we ask that you either message me privately in the chat box through Zoom your email address, or you could also send an email to the SURS Transition Fair email address so that we have your email and we'd be happy to pass along the resources that we have. The last point that I will just ask is that we ask that for anyone that has registered or is signing on by phone, if you wouldn't mind renaming yourself on Zoom, you go to the top right corner and click the 3 dots and then choose rename so that we know who is in attendance and we can pass along any relevant information to you. Okay, so I'm happy to introduce Katherine Aquino-Melendez. Katherine Aquino-Melendez is a senior attorney at the Cuddy Law Firm's Westchester office. She's a graduate of Florida International University and Hofstra University School of Law, where she was active in the Latino Law Student Association and a member of the Student Bar Association. And her practice is focused on special needs planning and trust administration. So Katherine, I'm going to unshare my screen and pass it over to you.
Thank you so much, and good afternoon to everyone. Thank you for joining and partaking in this presentation. Just going to figure out my screen share. 1 second. Can everyone see it? Okay, great. We've all had to become extra techy with the pandemic. All right, so today I will be talking about the guardianships and other options that exist for individuals with developmental and intellectual disabilities, and even for individuals that are, less, have different needs. And we'll touch on a little bit of everything. So important steps to consider, right, is always developing your child's team of advocates, whether they're an individual that has full capacity or need a lot of assistance in managing their needs. You want to make sure that you're developing a team of advocates, whether it's the school district personnel, healthcare professionals, like some of your team members, right, evaluators, coordinators, family members, accountants, financial planners, even attorneys. We always make note that this can change over time. You don't have to feel that you're committed to one set of team. If later down the line you choose to add someone or take someone out of the team, that's okay. It's an ever-changing group of individuals that will assist during different stages of your child's life. The some other things to consider, right, are special needs trusts, also known as supplemental needs trusts. There's two types of trust. There's a first party supplemental needs trust and a third party supplemental needs trust. Maybe you've heard of these trusts, maybe you've just heard of a trust. And so the difference is that if an individual with special needs has any assets of their own, you want to establish a first party supplemental needs trust in order to protect them from accessing means tested government benefits. And that's something that schools, should be talking about during transition planning, maybe even staff members at your location, right, at CERC, may even discuss this with your patients, right? The government benefits, right, OPWDD, SSI applications. I don't know if there's social workers that maybe touch on that at the Kennedy Center, but definitely schools should also be considering the transition planning, and this is part of transition planning. Then also, if there's money or assets that an individual maybe doesn't have direct access to, but a family member wants to leave property to them, there can be a third-party supplemental needs trust established. Estate planning, we'll touch on a little bit of that for an individual with disabilities, but estate planning pretty much entails, right, a last will and testament, which I'm sure a lot of you have heard of, as well as advanced directives, a healthcare proxy, a power of attorney, a HIPAA release that differs from the one that maybe your patients sign when they come into your office. This is more of a general inclusive form that also allows the agents designated as powers of attorneys or healthcare agents to access medical information. Letter of intent, you want to start planning for your child, whether it's a typical child or, a child with disability. Developing a letter of intent. What a letter of intent is a document that there's templates online if you Google them. You can also maybe access a copy from an attorney, but it's basically what your wishes are for your child, right? What they like, what they don't like, what type of lifestyle you want them to have. So basically what it says, right? A letter of intent for your child and their life. And this is beneficial if by chance, you have to appoint a guardian, maybe someone that's not yourself, or if, you pass away and someone, a legal guardian designated in your last will and testament has to then take in your son or daughter, right? So a letter of intent is a guidance for those individuals that will take over and care for your child. Now, it's something that can be revised very often. In fact, I have a client that probably every 6 months sends me an updated version of a letter of intent, and that's okay. We keep the most up-to-date version on file. It's ever changing. Children's needs, adults' needs change every day. So definitely make sure you're looking over it and updating it as your child's needs or likes and dislikes change as well. It's also even beneficial if you're having someone take care of your child for, a certain amount of time. Maybe if you're going on vacation and leaving them behind, or a babysitter, like my kid doesn't like cold pizza. Make sure their pizza is extra hot, right? Some of our kids have those preferences. Make sure you indicate that in the letter of intent. It's not a legally binding document. And like I said, it's an ever-changing document. It's an ever-changing document. So, it's not going to hold, like no one can hold you accountable for what you document in that letter, but it's a guidepost. OPWDD services and the application for SSI, right? You want to consider these. Some of your children may already be enrolled in these programs, but definitely at the age of 18, you want to apply for SSI, right? Supplemental Security Income. And the reason you want to consider applying at 18 if you have a child with disabilities is because your resources as the parent or caregiver will not interfere with the application process. OPWDD is also a great service office for people with developmental disabilities, and it offers a lot of services, community habilitation, respite services, job coaching, even housing assistance. So like I mentioned earlier, these are services that you want to discuss when you're having your transition meetings with the Department of Education or with social workers, whoever you can find in. Now, I'm sure you're all very anxious to know about guardianship, and guardianship has been a hot topic in New York State because there is somewhat of a shift happening with guardianship. There's two types of guardianship, right? In New York State, there's a 17A guardianship, an Article 17A guardianship, and an Article 81 guardianship. Now, 17A guardianship is what we typically request for individuals with intellectual or developmental disabilities. And these are individuals who cannot manage their own affairs. So you want to consider appointing a guardian, a legal guardian, once they're 18 and older. Some families say, well, my child is 22. Can I still apply for guardianship? Of course, you can apply for guardianship even when they're 50, right? Some siblings, their parents may not have applied for guardianship during, their life. And the siblings, right, the parents passed away, the siblings now are responsible for their disabled adult sibling, and they can petition for guardianship in those cases as well. The guardianship for 17As happen in surrogates court within the area that either the petitioner, right, the person seeking to be appointed guardian resides in, or where the individual with disability resides. So that's something to consider and, think about where you would prefer to petition. Just know that you probably want to petition where you see that individual residing a longer period of time, but again, it can be in either location. This guardianship should be initiated when the individual is 17, maybe even a little bit before 16 years of age. Why? Because it can take a little bit of time, right? Sometimes it takes a while to get all the paperwork completed. Sometimes you have to have your child be evaluated by a physician or a psychologist, right? Right before our presentation, we were speaking about that. And it's a little bit of a process, right? Sometimes you have to find another doctor because maybe your treating physician doesn't want to complete these affirmations that are required to be filed. So you want to give yourself enough time and also take into consideration where you're filing. Some courts have a lot of guardianships, a lot of petitions being filed in those courts. Some courts, unfortunately, in the city, right, in the New York City area, are extremely saturated with cases and they move a little slower. COVID-19 unfortunately put a dent in that process as well. And so thankfully the courts are now back full capacity, but are still moving a little slow and are a little backed up. So you want to keep those factors in mind when you're petitioning for guardianship. I have a note here that it can be done pro se, which means without the assistance of an attorney. Guardianship petitions are very simple. The forms are simple to understand and complete, and you can become best friends with the court clerk as well, who will guide you and provide you guidance on what to complete, what you need and whatnot. The clerks at the office have been a little hard to get a hold of again because of COVID-19, and some of them are still remote and whatnot, but they're very helpful to anyone and everyone. I myself and my paralegal contact the clerks very often and they're very helpful. So you definitely can do a petition by yourself. The one thing that I would say is that you should seek the assistance of an attorney if you have a little bit of a complex situation, meaning if maybe the parents are not on agreement, right, that the child needs a guardianship, you have conflicting sides from a parent. Sometimes if parents are in another country, that can get a little messy, right? And you might need a waiver to be executed and there's some issues. I had a client who her daughter's father was missing We know he's in the United States, so you have to see how much notice has to be provided to that individual to say, hey, I'm not in agreement, or I'm in agreement with the petition. So there's little complicated situations, but usually a guardianship can be easily done by the parents themselves. 81 guardianships, I'm just going to briefly explain what these are, but again, these are not the typical guardianships that are designated for individuals with intellectual or developmental disabilities. These sometimes, if so, would be based on a court order. Maybe if the individual suffered, had a lawsuit back when they were infants, maybe malpractice or lead poisoning or whatever the case was, right? And so a judge, excuse me, designated that these individuals need a guardianship as they get older, and these would be 81. The 81 guardianship is limited, right? Unlike the 17A guardianship that's plenary and can allow you control over everything, an 81 guardianship can be limited to certain areas, right? Maybe you have that knowledge, right, of your grandma that maybe is demented, or that individual, right, that has some mental health issues and may need a guardianship for managing of their health decisions or financial aspects, right, for like the demented patient, because you don't want their grandchildren taking advantage and asking grandma for $1 every day, right? So you want to be able to control certain aspects of that life and that person's affairs. And so that's what the 81 allows for, a more limited type of guardianship. These guardianships are filed in Supreme Court. It's a lot more involved. You definitely need an attorney for these types of guardianships. There's a guardian ad litem appointed to basically represent the individual you're seeking a guardianship over. And there's a lot more court oversight throughout the process. Usually, the guardian ad litem may even be designated to check in with the appointed guardian if there's an appointed guardian throughout that individual's life. Sometimes also, certain requirements are mandated by the court, but it's up to the judge at the court. And they're very expensive, right? Because there's so much more involved. There's more days of hearing. It can be a 1 day of hearing. It can be multiple days of hearing, discovery, paperwork, experts, witnesses to prove that the individual actually needs a guardianship for 81. So very different from a 17A guardianship. We'll go into 17A guardianships a little bit more in detail, and then we're going to touch on the alternatives to 17A guardianships in New York right now. But as mentioned, 17A guardianships are for individuals with intellectual and or developmental disabilities, right? Cerebral palsy, autism, intellectual disability, that are incapable of managing their everyday life. Now, you may have an individual that can, function pretty well in the community, but maybe, needs assistance or reminders to take their medicine, because they can go to the doctor and be prescribed a medication, but that's to the extent that they can, they'll manage. But maybe somebody has to remind them every day, hey, so-and-so, you need to take your medicine, and it has to be this dose, or maybe, half a pill. So then really they cannot manage their everyday life. So a 17A guardianship may be appropriate for that individual. Sometimes you may have someone that, can travel, but can they really travel by themselves? Or is it just because it's the same place that they're going to on a daily basis, and they know how to get to that one place, one route, and that's it? Like, if that street were to be closed, would they be able to come back home at the end of the day? Maybe not, maybe yes. But again, those are aspects that you need to consider for 17A guardianship. Then you have the pretty clear-cut cases that that the individual definitely needs guardianship and they cannot manage their own affairs. Those, are much easier to spot and confirm the need for a guardianship. But again, sometimes parents don't want to file a guardianship for those individuals. but then you're kind of left hanging, right? Because you really don't have the ability to continue making decisions for that individual after the age of 18. Yes, maybe one of you, the psychologist of Kennedy might have a familiarity with the patient and their parents because they've been treating them since they were infants. But, HIPAA regulations and whatnot require you at certain times to be like, sorry, mom and dad, you really can't partake. Or you may not have an issue having them participate because their child is significantly disabled. But not everyone is fortunate enough to sometimes have a team of professionals, especially in the medical field, right? That's where the concern comes into play most of the time, right? The financial and the medical health decisions. So you want to be able to have the authority or the ability at least to help the individual. The 17A guardianships are permanent, and like I mentioned, they're plenary, so they allow you access and abilities to control every aspect of that individual's person and property if you petition for both or one and the other. Usually, at least you'll be petitioning for the person's, the ability to control their health, education, life decisions, etc. The concern is if that individual later down the line, maybe their disability starts to subside, maybe there's a miraculous medication that comes into the market or something and, can switch something over, who knows? But then that individual can even go to court and say, I really don't need a guardianship. The burden is then on that individual to prove to the court that a guardianship is not required. And there have been instances, right? Back in the day, there were a lot of parents that filed for guardianship petitions. And recently, the courts have been confronted with these individuals now that are adults saying, I don't need so-and-so to manage my life. I can manage my own life. So you have to be careful, right, when you're petitioning for guardianship, that you're actually, if you're doing it by yourself, you're doing it with the mindset that your child does need a guardianship. Myself as an attorney, when someone comes to me and says, I need guardianship for my son or daughter, I'm really assessing the situation, especially if it's someone that, it makes me doubt sometimes. Like I have to look at documentation, I have to maybe meet with that individual. And there's been instances that I may say, you know what, I think they have the capacity to execute advanced directives based on my conversation and review of documents. So, at least we're conservative planners. So, we don't just file guardianship petitions for everyone that comes down through the door. We really want to make sure that we're doing this correctly so that in the future, you're not confronted with a situation like this, right? The individual then going to the court and asking for the guardianship to be terminated.
Katherine, I'm sorry to interrupt. There's a bunch of questions in the chat about what you're talking about. Do you want to go through them now, or do you want to wait till the end and we can go through some of them?
We can go through a few of them.
Okay. So one question is, can someone be added? Like, can I add my daughter for when I die that she takes over?
Okay, yeah. And we'll touch on that, right? The guardianship, you want to designate maybe a standby or an alternative standby to have backups. The one thing is they have to be 18 years or older to be included on the petition.
Does 17A cover financial and health issues?
Yes, the 17A. So if you petition for person and property, you will be able to manage that individual's health decisions, educational decisions, banking, whatnot, and then the health part as well. The property, that allows you to also manage any assets that they may have. There are certain assets such as indicated on this slide, SSI, that's not counted as property. If you have a supplemental needs trust, that's not counted as property. So maybe like brokerage accounts, bank accounts, that will be property and it'll be tied to the court.
This is a multi-part. First off, there's a comment, some bar associations provide free legal assistance for 17A, like Brooklyn Bar Associations. That's actually good to know.
And the court clerks also free assistance.
And then here's a multi-part. What assets are included? Our care manager has gotten us very confused regarding Medicaid, OPWDD, and what's covered. For an under 18 child, does a 529 account count, or an ITF where they are a beneficiary? And how do these accounts affect Medicaid eligibility when the child turns 18?
So that deals with another aspect of the planning, right? Medicaid, and that's a little bit more detailed. So I'm going to skip over that one with all due respect.
The last part is guardianship all or nothing, or are there shades of gray? And can you talk a little bit about the supportive decision making?
Yes, I will be getting to that.
Okay, thank you.
Fantastic.
I think we're good for the moment.
Okay, great. Okay, so the petition, that you want to make sure you're listing every name, address, date of birth, right? All the information about the individual is going to be included. The property, right? So bank accounts, brokerage accounts, you know, it varies depending what type of account. They're custodial accounts that may be out of the plan. So you want to, like that person that I had to skip that question over, I apologize, but you know, that's a little bit more case specific. So everything varies. Standbys and alternatives, right? So you're petitioning as the parent and you have older children that you would like to designate as standby. So the person behind you, in case something happens to you, whether you become incapacitated or pass away, that person is behind you and in line to step up as a guardian. Then you can also designate alternates to that standby, right? So a third person. You can have co-guardians, you can have co-standbys, co-standby alternative guardians. You can figure out, I mean, you can even have 3 guardians petitioning together, and those would be considered co-guardians. And so you definitely always want to include a standby at least at the minimum after yourself, because what if something happens to you, right? You want to have someone as the backup. If you have a co-guardian, that person, if something happens to you, can continue to act. But if something were to happen to both of you, then you have the backups. The one thing to keep in mind is that a standby has 180 days to petition to the court when they are ready to act, right? So if you pass away and your standby knows that you passed away, hopefully it's someone that has some relationship to you and has familiarity with the family dynamic. That person has 180 days to go to the court and say, court, I'm here to serve as the guardian of Cindy Lou, because I know, and the guardian has passed away, no guardians are designated. Then the court will, have a proceeding and appoint that person as now the guardian. So you want to keep that in mind. If a family member is not being named, you have to indicate why. And if it's a sibling or a parent that's not being designated as a guardian or standby, they have to sign waivers, basically waiving the right to be appointed. And then the people that are being designated have to sign consents. And we'll see that in the slide momentarily. Listing doctors and banks, right? So if there's property, what banks the court is going to have association with, and doctors. Who are the doctors that are going to complete the affirmations? We'll touch on what those affirmations look like in a little moment. One question that always trips people up is, why should I be appointed guardian? It's like, well, I'm the parent. Yes, but you want to expand a little bit as to why you should be appointed. You can be the parent, but maybe not the best parent, but you want it, right? So you want to designate, I'm the parent and I know my child's best needs, and et cetera, et cetera. Also, everyone that's petitioning as a guardian will have to submit an affidavit. This affidavit is going to ask for your educational history. It's going to ask for criminal history. It's going to ask for narcotics and alcohol abuse questions. If you've committed a felony, more likely than not, you will not be appointed a guardian. If you have a misdemeanor on your file, there may be instances that you will be approved as a guardian. But again, it's very case specific and depends what the situation was and how long ago it was, right? Because they want to make sure that the courts want to make sure that they're designating an individual that's going to be able to care and be there for that individual. Certification. So these doctor's affirmations have various names, doctor affidavits, certifications, whatnot. you need one physician and one licensed psychologist, or two physicians, one with expertise or familiarity treating patients with intellectual or developmental disabilities. Most of these affirmations cannot be more than a year old when you submit them to the court, and the evaluation or the checkup has to be relatively recent. Every jurisdiction varies. Some require you to, like the doctor, to have seen the patient within the last 6 months. Some say a year is sufficient. So you always want to make sure that you're checking with the court what the requirements are. Make sure that your doctors answer every question, because sometimes they may skip a question, and you want to make sure that that's not going to hold up the process, because the court will kick back those documents to you. So make sure that the doctors are completing every single question, even if it's an NA, that it's being indicated, right? But at least every question is touched on. Also, if there's reference to any evaluations or IEPs or evaluation, school evaluations that they're referring to, that documentation is also included with the doctor affirmation. I have a point here, and no offense to any of the doctors here, but it's usually what takes the longest for the guardianship petition because you're so busy, right? So it's usually what takes the longest. But these are very critical, because this is basically going to lay out the foundation for the court as to the child's needs and disabilities. One question that's also included is if the child can be excused from appearing at court, and if they'll have understanding of what happens at court. So, that's something that doctors get to opine on before the court guardian ad litem can opine and direct the judge of the status of the individual. Waivers. So as I mentioned, waivers is for anyone that is waiving service and that are not being included in the petition. The consent is, right, you're consenting to serve as requested in the petition, whether it's a guardian or standby. And then there's the OCFS form. This is the New York State Office of Children and Family Services form. And it requires you to jog your memory a little bit. You have to include whoever's petitioning as guardian has to include 28-year history of their addresses. If you don't remember the exact street or apartment you lived in 28 years ago, that's okay. But you have to get it as close as possible. You have to try to include as much information as possible in that questionnaire section, because this document is then sent to Albany and it's processed through the state. That then comes back to the courts and reveals, any child abuse history, if the child themselves were ever abused, and you're listing, usually it's the guardians and any adult sibling living in the house. And some courts also require standbys to complete this form. So, it takes a little bit of brainstorming to remember all those addresses. Once you have everything in place, you want to file the petition and submit it to the court. They'll either accept it right then and there, right? And some courts are requiring you to file them electronically. Some of them are allowing you to just mail it or take it in person. I mean, I don't know if they're all allowing you to go in person these days, but that was usually what you could do before COVID. And then if there's something missing, they'll let you know. If you submit something, like I mentioned, they're a little behind. So we'll get notices from the court maybe months later after submitting a petition saying, you need X, Y, and Z, right? Because every court varies. Recently now, the Queen's Court is asking for citizenship statuses or like some sort of citizenship record, which they never did, and that's not a requirement, but that's what the Queen's Court is suddenly doing. So we never submitted that, and then they came back to us like 6 months later saying we need this. The court will then, once they get everything, look through everything, process everything, they'll submit a citation. And what a citation is, it's a document that says when the hearing date is happening. And it'll direct you to serve all the individuals whether it's the individual that you're seeking guardianship over, you have to serve either the representative of the home if they reside at a residential facility, the disinterested parties, mental health, hygiene, legal services, right? There's a slew of people that you have to serve. And then submit to the court an affidavit of service stating that you've served all those individuals. And again, the court clerks can always help you. And as someone mentioned on the chat, Brooklyn Legal Services, I believe, was organization that can also help. Okay. Then you're going to file the affidavit of service. Some courts also require guardians to be fingerprinted. New York County is requiring, or at least was requiring, individuals to be fingerprinted. I think a little bit after the pandemic, they've stopped that requirement. You know, if you have a reason why you can go get fingerprinted, at least in some cases that I've had in New York County, my proposed guardians have said, you know, I don't want to go, I don't feel comfortable, the pandemic, this, that. And I submit an affidavit on behalf of my clients indicating why they should be excused from being fingerprinted. Then the hearing happens. The hearing varies from county to county, right? Westchester County, the surrogate, who's the judge in surrogate's court, that surrogate required only the petitioner's attorney, if they were represented by an attorney, to appear. If you were being represented by yourself, right, you didn't have an attorney, you had to appear, but you never had to take the individual you were asking to be a guardian, show up to court with you. Now that surrogate is requiring for the attorney to appear with their client, right, the proposed guardians, and the ward or the individual with disabilities, despite what the doctors are indicating on the affirmations that that individual should be, excused or whatnot. So even in his court, things have changed. In New York County, and not to mention that in Westchester, before the pandemic, you would all go in and sit in one room, right, in the hearing room, and he would hear all these cases back to back to back. So you would hear everyone's case. And then you would have to wait a few months to get the letters of guardianship and the order. New York County, you would go meet with the surrogate in a very small, almost like an office-like room. And she would only require the guardians to appear and the attorney, one of the surrogates. The other one requires the ward to appear as well. But then you would get, or you still get, your letters and order right then and there as soon as you walk out. So they make a determination right on site. So every court varies, every judge varies, right? So like I mentioned, there's 2 surrogates in New York County, and they both have very different ways of handling guardianships. Lastly, letters of guardianship and orders will be mailed to you. For example, if you're in like Westchester County, in New York County, you'll get them right then and there. Queens, I don't know how Queens has been doing things recently, but before they would also mail them out to you, and the Bronx. So, I don't know if things have changed. I haven't filed guardianships there I haven't had an appearance after the pandemic. Any questions, Erin?
Yeah, there's a couple.
Okay, we can touch on those.
So one of them is, so to open a bank account, you have to have property as well as person done?
It depends what type of bank account you're opening.
And then there are several requests for access to these slides or comparable material.
Okay.
If anything, you have anything that we can disseminate to people, there's several requests for that in the chat.
Okay.
And then there's also a question, does the waiver need to be for all immediate family members that do not want to be included in the petition, or just anyone that has specified that they do not want to be included?
No, so it would be any family member, immediate family members, or adult siblings of that ward.
Okay, I think that's all the questions for now.
Okay, great. So I'm going to touch on the advanced directives, and then we'll go into supported decision making, because I know I have so much time to go But advanced directives, right? This is the other option. If your child is 18 years or older, that's when they can execute advanced directives. It can be really, advanced directives are for everyone. So everyone should have advanced directives, with the exception of you don't have the capacity to understand what you're signing, of course, and that's when a guardianship may be applicable. What are advanced directives? Healthcare proxy, right? It allows for an individual to access or make medical decisions. For an individual, they become incapacitated. The power of attorney gives someone the ability to manage all financial matters, and that becomes effective as soon as your agent signs. A HIPAA release, authorization for agencies to share medical information to your agents. A living will and a disposition of remains. The living will indicates what medical treatments you want included, right? For example, artificial respiration or artificial, or nutrition. And then the disposition of remains, what you want or how you want your remains to be disposed. The living will and disposition of remains, at least in our office, we don't have young adults execute, because even for myself as a grown adult in the field, it's hard for me to, it was hard for me to even think who I wanted and what I wanted. So young adults, we usually don't have them execute those two documents. But like I mentioned, right, if I had a client who came to me and said, I think my daughter needs guardianship, and when I assessed, I was like, no, I think maybe she would qualify more for advanced directives. Like, I don't feel comfortable filing a petition, and I think she has the capacity to understand these documents. So then we proceeded with the advanced directives. Now, remember I mentioned at the very beginning how guardianship is a hot topic in New York State. That's because supported decision-making is making its way into the state. Supported decision-making is not it's not legally binding in New York State. There's no law that requires the implementation of supported decision-making, but it's definitely something that is being talked a lot about, and there even talks about maybe even eliminating 17A guardianship for some individuals, which, there's debate on, right? I mean, some individuals just wouldn't be able to come up with a team for supported decision-making and really do need 17A guardianships. What supported decision-making is, it's literally what it sounds like. It's a group of individuals that help you make decisions, right? For the individual with disabilities to make their own decisions. Granted, this should be the same objective for an individual that has a guardianship, if they can, opine and comment on what they'd like to be done. But in this situation, if you don't want to file 17A guardianship, you can have a supported decision-making agreement. And agencies in New York there's a supported decision-making of New York that allows you to look up and create your agreements or look into the programs. Now, you have to make sure that you have a team of people to help you make these decisions. There's no specific number of people you need on your team, but you want to consider family members, teachers, right? Health providers, lawyers, job coaches, etc. And what you want help with, right? Is it just health decisions? Is it just living decisions? Both, money, personal care, etc. So the individual with disability kind of makes the rules as to what and who to be part of this team. And you want to explain to these individuals that you're asking to be part of your team, like, hey, are you willing to join this team? And here's the agreement, right? So it's something to consider. The one thing is, because it's not legal or official in New York State, it's not recognized, is that you want to then consider having that individual with disabilities execute advanced directives of their own, right? Because again, it doesn't really authorize anything. Potential issues might occur when you're in the hospital, if you go to the ER, right? And the doctors can be like, there's no legality to this. Like, you're showing me an agreement, but it's not a legally binding agreement. your parents don't have to be involved in whatever decision we talk about. So you want to be aware that if you're having your child set up a supported decision-making agreement, that you also have them execute advanced directives. But remembering that they have to have the capacity to execute these. And that's it. So I have 10 more minutes for questions.
So we have a couple of questions in the chat. One is, if we move to a different borough, do we need a new guardianship or no?
Okay, so if you file for a guardianship, let's say in Queens, and you move to the Bronx, usually you don't need to file a new guardianship. You can just transfer the guardianships. The one thing is that eventually, some things may come into play. So again, it depends. It depends, because sometimes, for example, like you might start services like government benefits in one borough, and then, things are different or whatnot, and you're dealing with two separate courts. So it depends.
There's another question. Right now, I heard that New York State supportive decision-making program is not taking new participants. They are working on the legislation to make it a permanent part of New York State, but not sure where individuals can go right now. Do you know?
So I would go onto that website, the supported decision making. There's a website, supporteddecisionmaking.org, I believe. Look into that. And yes, there is a lot of legislation happening right now. Like I mentioned, there's a contemplation of even eliminating some other options. So definitely check out the supported decision making webpage or supported decision making New York State.
And so we have the SDMNY through Hunter. That website is in the chat for anyone that might be interested.
Perfect. Thank you.
Are there any other questions? I think I hit everyone's question in the chat, but if I missed any, please let us know.
Yeah, and one thing I do want to mention about 17A guardianships is that they also are not meant to, right? Because I know some people have been calling our office with the whole Britney Spears conservatorship happening. You laugh, but it's true. So conservatorships do not exist in New York State. And the one thing about 17A guardianships is that although you have control over that individual's life, you cannot take away their constitutional rights. So if that person wants to procreate, they're allowed to do so. If that person wants to marry, it's a constitutional right. If they want to go vote, right? That was questions I was getting last year when the elections. Can my child go vote? I have a guardianship over them. Yes, they can vote as long as they know what they're doing. Excuse me. As long as they know what they're doing and, have some sort of understanding, they can go and fill in whatever little circle in the Scantron. So your constitutional rights are not violated. And it also is not like a get out of jail card. Because sometimes individuals also feel like, well, maybe my child has a tendency to like grab yellow balls when they go to the store and walk out with them. The store may call the police and they may be found, as guilty of theft. It's not a free get out of jail card that you have a guardianship over that individual. Granted, as the process goes along and you can explain and, a proceeding happens that this individual may be, just is attracted to this, it's part of their disability or whatever, to just grab yellow balls, that can get you out, but not just because there's a guardianship. Like they're still held accountable for their actions. Okay.
Any other questions? Okay.
Sorry, can I speak? I didn't type it in. I'm so sorry. If a person, my son is 25, and he can make decisions pretty much about everything except for money. So like if the doctor is asking him questions, he could answer. He understands a little bit. If he'll advocate for himself, he'll ask questions. The only problem besides cooking is money. He does not have any money control. Would guardianship be appropriate in that situation?
Potentially, depending on his maybe IQ. IQ is not the, definitive score, but depending what the disability is, depending on his IQ, depending on what, his abilities in every other area could be, that can be an option. Or maybe even advanced directives. You can have him sign a power of attorney and you can manage his bank account, or you can say, I'm going to manage your money type of thing, since you really can't manage it. So it depends. It depends.
Any other questions? Okay, well, thank you, Katherine. That was incredibly informative.
You're welcome. Thank you.
Very helpful. So as a reminder, we're going to be sending out an email that will include some transition planning resources. We will also be including the link to the survey or questionnaire that we ask that people please complete to give us some feedback. And we also wanted to share with you some information about the SPARK study. SPARK is an online research partnership with the goal of speeding up autism research to understand causes and treatments of autism. And it's something that individuals can participate in entirely from the comfort of their home. So this is a little bit of information about it. We will also, in the email that we will be sending out, share information with this website at the bottom for anyone that might be interested in participating. And just a reminder, we have our third in our series of 3 webinars scheduled for next Wednesday from 12 to 1 p.m. and it's on OPWDD eligibility services and self-direction. And the webinars are all being offered from 12 to 1 in English and then 1 to 2 in Spanish. So thank you everyone for attending. Katherine, thank you very much for your talk.
Thank you so much.